Okay. So to continue, we will be discussing the remaining aggravating circumstances, and we will discuss the advantage be taken of superior strength. Now, for there to be advantage be taken of superior strength, the following elements must be present. That strength of the offender is superior to that of the victim, and the offender takes advantage of said superior strength. Now, in order for the aggravating circumstance of superior strength to apply, there must be evidence that the offender is of superior strength than the other. It cannot be presumed, and it has to be clearly established in the set of facts. So that you really have to prove that the offender here is of superior strength. Now, what are your examples of superior strength? For example, when two or more people committed the crime, there is superiority in number, and it would definitely give the offender or all of the accused superior strength. Or when one is armed with a weapon and the other is not armed with a weapon, then superior strength is apparent. So very common siya, like for example, for individuals with a gun and an individual without any wala siyang bitbit na gun. Sorry, medyo distracted ko because I'm having a migraine, so please bear with me. All right, let's move to the next. That the means be employed to weaken the defense. So, for there to be means employed to weaken the defense, the following requisites must be present. That means were purposely sought to weaken the defense of the victim to resist the assault. And that second, that means used must not totally eliminate possible defense of the victim. Otherwise, it will fall under treachery. Now, when you try to weaken the defense of your opponent and you kill him, that is already aggravating on your part because you do not give him the chance to defend himself. So an example of that is, for example, accused gave sedative candies to a woman so that he could drug her, so that he could proceed to rape her. So that is one way of employing to weaken the defense. Imong gi-drug ang babae para ma-rape her so that she will lose consciousness at pwede siya maka-resist sa imuha. Second, an example in People versus Xiao Tong, the accused while fighting with the victim threw sand. So nabayan niya sand ang mata sa iyang opponent so that ma-blind siya and proceeded to stab him. So the aggravating circumstance was appreciated there. And lastly, the accused, while struggling to fight with another, threw a cloak, kanang fabric with the cloak, kanang cloth, ilaban niya sa head sa victim so that di siya kakita para mapatay niya siya. These are some examples of how you employ the aggravating circumstance of to weaken the defense. Any questions so far? None?
None, sir.
Yes? May pangutana?
Wala, sir.
Wala. Okay. Ano hinay mo niya po ang audio? Okay.
Sir, pangutana, sir.
Sige, Mambot. Go ahead.
Sir, itong una gani, sir, nga topic, sir, about sa atong superior strength.
Sige.
Sir, what if ako og si Pacquiao ang magsumbagan, sir? Na ba makakuan ba ko na?
Okay. So like I said, it cannot be presumed na mas hawt si Pacquiao sa imuha in terms of strength, but you have to establish which one of you has a superior strength. Kana na siya when you try to allege this aggravating circumstance, Nagas yung 1 point, Mr. Sumambot.
Bali sir ang kuan ang makitan lang di ay sa bali
Oo,
ebidensya.
oo. So
Pwede ba di mo base sir sa
just because Pacquiao is a world class boxer does not automatically mean that he has the advantage or has the superior strength over you, di ba? Okay, you cannot presume man dapat ma-establish yun nato na superior strength si Pacquiao sa imo siya over you.
dili de enough ba siya sir ang pagiging athlete niya sir? Okay sir.
All right. Anything else? So let's move on. That the act be committed with treachery or alevosía. There is treachery when the offender commits any of the crimes against the person employing means, methods, or forms in the execution thereof which tend directly and specially to ensure execution without risk to himself arising from the defense which the offended party might make. So treachery is, ang essence aning treachery is unexpected attack. Unexpected attack because you did not give time for the defendant or the victim to defend himself. He was really like surprised from your attack. So the elements are the following. At the time of the attack, the victim was not in a position to defend himself. Second, that the offender consciously adopted the manner of attack to make the victim defenseless. So for example, si Sumambot nagdala og bolo. Yan, na siya kalagot kang let's say kang Orculio. Yan, let's say they are 10 meters apart. Yan, gi-brandish ni Sumambot iyahang bolo. Ano siya na, patyon di ka. Gina-brandish niya, gina-wave niya iyahang ang bolo. Patyon di ka. So, is there treachery in that scenario? What do you think?
Bali sir, murag nag-threaten pa lang siya sir or naka-attack na gyud si sir.
Nag-threaten lang siya. They are 10 meters apart and ginabuhat lang ni Sumambot is ginabrandish niya ang bolo kanang muna ginapakita good na patyong di ka kanang gani kanang na ginagunitan niya unya kanang muna gin-intimidate niya si Orculio. But they are just 10 meters away unya. Wala sila they're just standing. So is there treachery or alevosía in that situation?
Yes, sir.
Why? Why Pericano?
Sir, according to the second element of the sir, that the offender consciously adopt the manner of the attack to make the victim defenseless. The moment na gina-wave na niya ang bolo, the offender is nag-adapt na siya manner to attack the sir kanang victim niya. Ang victim kay defenseless na siya.
How about the first element? Nag-attack na ba siya or wala pa? Diba? The time of the attack, the victim was not in the position to defend himself.
No sir.
Yes, no. Why? Why, Mr. Casero?
Sir, the first element sir is kay wala pa mong siya nag-attack murag nag-ball pa lang sir. Na wave pa lang siya ang bolo sir. Pero kabalo nagikuan.
It's actually when you threaten someone and then you are just there to threat, igo na ka naggunit sa bolo, unya kabalo ang victim or would-be victim na uy na siya bolo, there is no treachery there because he was apprised na meaning ang imong victim knows that you are armed. So asang surprise niya or unexpected attack, di ba? But what if si Mr. Sumambot, ito na nag-answer, si Pericano. Africano, Bercero. All right, what if the scenario is like this? Same scenario ha, si Mr. Sumambot, nagbrandish siya og iyahang bolo. Unya, ingnan niya si Mr. Orculio, patyunti ka. Unya, i-brandish lang niya, I mean, gina-wave lang niya ang bolo sa towards iyahang opponent. Pero, ikalit og hublot si Mr. Sumambot og gun from his likod, unya gitira dayon gibaril dayon si Mr. Orculio. Is there treachery in that scenario?
Yes,
Yes,
sir.
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 Why?
Yes, sir.
Because the unexpected attack, sir, na gibunot niya ang gun to shoot Mr.
There is
Orcolio.
no time to defend himself, sir, from the gun.
Okay, very good, Mr. Samambot and Paricano. So in the second scenario, Mr. Orculio was only notified of the fact that you are armed with a bolo, but he did not know that Mr. Somobot brought along with him his gun. So when he was surprised when he immediately saw Mr. Somobot drew the gun from his side likod and proceeded to kill him. So there was a surprise attack. So in that case, there is alevosía or treachery.
Consider magyapon na, sir, na concern murder, sir.
Because for murder to be present, the qualifying circumstance of treachery, superior strength, evident premeditation should be present.
Okay, sir.
Very good, Mr. Marcelo, for recalling. Now, in People versus Bacona,
Sir,
yes.
ang mga murag bitag gani, sir. Mahulog ba nag-treasury gyapon?
What's bitag? Sorry.
Bitag, sir. Kumbaga man ng kung saan pangaso pa, sir, litag ba?
Litag?
Bitag.
Bitag. What's
Bitag, sir, bitag. Sir, trap.
Trap.
trap? Okay.
Line mine.
Okay. Yeah. If the
Mine, sir.
elements are present, for example, at the time of the attack of the victim, he was not in a position to defend himself, and that kaning akusado, he really adopted the manner of that in order to make sure that the victim is defenseless. And why not? For as long as the elements are present. So you always go back to the elements pag mangutana mo. Treachery. So elements of treachery. Was there a surprise attack? Yes. Did the offender consciously adopt this para mahimong defenseless ang victim? So yes. Any questions so far?
No, sir.
Wala na, okay. Sige. So let's move to People versus Botona. A was at the market waiting for B. So while waiting, C arrived as asked when B would arrive and left thereafter. B arrived at his store and A bought fish from him. Before the transaction could be finished, it rained and they took shelter at a near pig pen. After 10 minutes, he came near them and shot A twice at the side of the head with a handgun, killing him. So the Supreme Court here said that the attack was sudden. The victim had no inkling that the offender would arrive and shoot him point blank on his left temple. The victim had no opportunity to defend himself and fend off the attack. The crime was attended with treachery. So we have to remember that in treachery, there is a sudden and unexpected attack. For a second. All right, sorry. Had to fix my. Anyway, so that's how you execute, or that's how you appreciate treachery in aggravating circumstances. Sorry for the visual, very for the picture, it's very brutal, I know, but this is one way of where am I? I'm lost for a sec. All right, klaro ang slides.
Yes, sir.
Okay. That means we employed or circumstances brought about which add ignominy to the natural effects of the act. When you say ignominy, kanang unsa ba, kanang humiliating, kanang adds degrading, it's very degrading on the part of the victim. That's ignominy. So if you add ignominy to the crime you have committed, then it will aggravate the crime you performed. So elements are the offender perpetrated ignominious act when the victim was still alive. Second, the ignominious attack put the victim in a humiliating condition. And third, the ignominious act was perpetrated with intent to augment the moral pain of the victim. So if you can see there, very sorry, it's very graphic. The picture here depicts of a woman being raped by several men. So under our jurisprudence, Mongol, if you are raped by more than one man, nakakahiya na siya. It's very humiliating. That's ignominy already on the part of the woman. So although I nakuha na ko sa Google the picture, although it's foreign, but just to get the picture. Now, in People versus Cortesano, ignominy was appreciated in rape where the accused forced another person to rape the victim and laughed as the latter was being raped. And the sisters of the victim were even ordered to look at their naked sister after the accused had raped her. So diba, ignominy is humiliating and adds moral pain on the part of the victim. In People versus Valia, where the pubic area of the victim bore blisters brought about by a contact with a lighted cigarette. So in this case, ang cigarette gisunog niya sa pubic area sa babae ba. So mo na nagka-blisters ang pubic area sa babae. So again, that's adding ignominy to the victim. And lastly, in People versus Fernandez, where the accused plastered mud on the victim's vagina right after she was raped. So gibutangan og mud ang iyang pipi, di ba? After raping. So that's very, again, humiliating and degrading on the part of the victim. So if kanang mga sabay tawag ani kink ba ni, if kink ba ni, or I forgot kung sa term sa sexual na unsa topic. But again, these are examples as in order to appreciate ignominy. As a matter of fact, I've read in one book by one author, he said that if an accused rapes a woman doggy style, then it is already ignominy on the part of the woman kay murag ginigrade daw niya ang kinabuhi sa buhay like that of a bitch or of a dog. So mana dog style ang babae kung mag-rape, okay, na ignominy daw na siya. It would be different if, of course, if it is consensual. So you can do any position you want if it is consensual, but if it is rape, ayaw i-doggy style kay consider na siya as ignominy. Any questions so far?
Sir, ang ignominy, sir, that is only applicable on women, sir, or also for men, sir?
For men. Murag ang very common manggod na ignominy is babae. Ang nabasa na ko na jurisprudence ba? Mostly. Pero pwede po, like for example, lalaki, gi-rape ang lalaki. Let's say, nagid ako'y nabasa na a young male gi-rape siya anally, gilubot siya. So that is humiliating on his part. Kay gilubot siya by another man.
Okay, sir. Thank you.
All right. That the crime be committed after an unlawful entry. So you commit a crime by unlawfully entering a window, a door, or any entrance not intended for that purpose. So kani ang elements niya. The entrance in a building, house, or edifice is made by a way not intended for the purpose, and the crime was committed after the entry. So dili door, I'm sorry, my mistake. It's not a door, but example namin makita ni edifice or ini kanang agihanan na sa mga aircon kana if niagi mo diha, that is already unlawful entry. Very common na siya in diri sa mua sa Baganga. Kanang ginabuhat nila, ginatanggal nila ang aircon kay para maka-access sila diri sa sulod sa mga balay na mo na mga para makapangawat. Now, another example for that is A, in committing the crime of rape against B, gained entrance to the victim's house through the window. Now, ano i-appreciate ang window diri? Because window is not your usual entrance in a building or house, di ba? Usually, kung sa man ka ng door, mangyod dapat. Next, there is an unlawful entry when an entrance of a crime Fuck. I'm sorry. There is unlawful entry when an entrance of a crime of a wall, roof, floor, door, or window be broken. Mo na siya if gubaonin mo ang door just to gain entrance kaning mga roof, floors, or doors, or windows. So there is actual breaking. Now, elements of this aggravating circumstance include the following: that offender unlawfully broke a wall, roof, floor, door, or window of a building, house, or edifice. The breaking was done as a means to commit a crime. Now, in People versus Labosa, just to exemplify this, the crime committed by the accused for killing the victim is homicide, aggravated by the fact that they broke a wall or door to gain entry, since the accused rammed the door off its hinges in order to gain entry, meaning they deliberately rammed the door from its hinges, kanang door, kanang side sa door na naka-attach ba sa wall, para lang maka-gain entry sila sa balay and successfully kill their victim. Holy shit, usap ni. Okay. The crime be committed with the aid of persons under 15 years of age. Now, ano aggravating man eh? Because according to one author, according to Justice Regalado, one of the great luminaries of criminal law, he said that the circumstance of aid of minor is intended to prevent or discourage the exploitation of such minors by criminals, taking advantage of the irresponsibility and the leniency of the law for youthful offenders. So, para to give justice to those individuals who take advantage of minors. Now, an example would be the Mark caused Vince, a 12-year-old, to climb the wall of the house of Dieter in order to enter the same through his window, and once inside, ordered this minor to take the valuable jewelry from the cabinet. So, for individuals who use the aid of persons under 15 years of age, their liability will be aggravated if they utilize these minor children. By means of motor vehicles, motorized watercraft, airships, or other similar means. Now, when the elements of motor vehicles are the following: that motor vehicles, watercraft, airships, or other similar means were used to commit a crime, and the use of the motor vehicle or other similar means must be deliberately adopted as a means to commit a crime. So, in People versus Calixtro, the offenders here went to the bank using a jeep, and while committing bank robbery, one of them was left behind the steering wheel of the parked jeep, and then, after committing the robbery, they boarded their jeep and sped northward. So since they used the vehicle, a motor vehicle, in order to perpetrate their crime, then their, let's say that's robbery, then their robbery will be meted out with a penalty in its maximum period or as aggravated by means of motor vehicle. So in short, sir, kung mangawat, mister, magbike lang, mister, kaya wala man siya na fall under motor vehicle, pwede, kaya para sa lang mo, sa medium period lang inyong robbery.
Madakpan yun naman, sir.
Samot, no? Nagbike lang. That the wrong done in the commission of the crime be deliberately augmented by causing other wrong not necessary for its commissions. So this is the principle of cruelty. So when you add cruelty to your crime, the crime that you will commit will be aggravated to its maximum. So the elements are the following. Offender perpetrated the cruel act when the victim was alive. The cruel act is not necessary to the commission of the crime. And lastly, the cruel act is done with intent to prolong the physical pain of the victim. Now to exemplify this, we have People versus Arreglado. Ang gibuhat aning offender kay he cut off the upper and lower lips of the victim while the latter was alive. So clearly there is cruelty there on the part of the offender. Second, People versus Bergante, the accused, after the victim was hit on the head by a piece of mangrove, pierced the victim's eye with a bolo. So, gihapak na ganig mangrove, gitusok pa ginugbo ang iyang mata with a bolo. So, clearly, cruelty is present. In People versus Laura, adlo kani, accused gagged the mouth of a 3-year-old child with the use of stocking. So, gisulod ang stocking sa sulod sa mouth sa bata kapag di siya kasyagit o di siya kasulti. Dumped him with head downwards in a box and covered the box with sacks and other boxes, causing slow suffocation that caused the child's death. So, very cruel. Matabang niyon sa ba? On. Okay, so that's the end of your aggravating circumstances. Do you have any questions so far as to its application? Do not worry kay dilita mo let's say for example, the penalty of this crime is blah blah blah. Please calculate kung sa iyahang penalty if the aggravating circumstance. Of course, I will not do that because that is not your job. But your job is to know that if this is present, the situation or the crime committed would be raised to its maximum period. Hence, you should be able to detect in a set of facts whether or not aggravating circumstances are present, whether exempting circumstances are present, or mitigating circumstances are present. So, kana ang inyong role as police officers. When you prepare your police investigative report, you have to allege there in your report what circumstances are present in order to help us prosecutors reach a sound resolution whether or not to put the person or the offender in jail, to dismiss the case, or to file the case in court. So that is your vital role as police officers. Any questions so far? Dan?
Wala, sir.
Okay. Let's move on to chapter 5. alternative circumstances. Yun lang siya actually. So the concept, like, sa mali. How do you move this? Yeah. All right. Ay, salamat. Thank you, Lord God. So Article 15, the concept of alternative circumstances. So those which must be taken into consideration as aggravating or mitigating according to the nature and effects of the crime and other conditions attending its commission, meaning we do not know whether these circumstances would be mitigating or aggravating, but it would depend on how it is applied or how is it present in the situation. So they could be relationship, intoxication, and degree of instruction and education of the offender. So alternative circumstance of relationship shall be taken into consideration when the offended party is the spouse, ascendant, descendant, legitimate, natural, or adopted brother or sister or relative by affinity in the same degrees of the offender. And the intoxication of the offender shall be taken into consideration as a mitigating circumstance when the offender has committed a felony in a state of intoxication, even if the same is not habitual or subsequent to the plan to commit said felony, but when intoxication is habitual or intentional, it shall be considered as aggravating circumstance. So I will explain that thoroughly. Wait, ha? The concept here is that alternative circumstances are those that must be taken into consideration as aggravating or mitigating according to the nature and effects of the crime and other conditions attending its commission. Hence, it's a case-to-case basis. How do you know if the relationship between the offender and the victim is mitigating or aggravating? So in crimes against property, it is mitigating. So for example, malicious mischief, gubaon mo ang unsa, no, not malicious mischief. Yeah, malicious mischief. Gubaon mo ang fence sa imong brother or sa imong kay tungod kani imong brother ni encroach sa imong unsa sa imong area or whatever ba, or let's say for the apparent reason. So muna, it is mitigating because of your relationship. Kasi magkapatid kayo. But there are exceptions as to whether or not it should be mitigating. But there is also an exception wherein no criminal liability will attach. So that is under Article 332, persons exempt from criminal liability. So no criminal but only civil liability shall result from the commission of the crime of theft, swindling, or malicious mischief committed or caused mutually by the following persons: spouses, ascendants, and descendants or relatives by affinity in the same line. Second, widowed spouse with respect to the property which belonged to the deceased spouse before the same shall have passed into the possession of the other. Brothers and sisters and brothers-in-law and sisters in living together. The exemption established by this article shall not be applicable to strangers participating in the commission of the crime. So let me rephrase by example. So let's say not brothers and sisters. Let's use another, let's say cousins. Not cousins by let's say not by in the same line. So that, for example, second cousin na nimo or third cousin kana, allowed na siya mag-attach ng mitigating circumstance. But please remember that Article 332, you cannot file a case of theft, swindling, malicious mischief against your spouse, ascendant, descendant, your widowed spouse, your brother or sister, because they believe in the sanctity of relationship. Kasi kabalo na sila na pwede pa yung mapag-usapan. So that's why the law recognizes that, and hence it's only either mitigating or you could be exempted from criminal liability. Now, how will you know if it is aggravating? In crimes against persons, in cases where the offender or when the offender and the offended party are relatives of the same level as killing a brother, adopted brother, or half brother. So it is always aggravating also in crimes against chastity. So we had one case in Katiil wherein we learned that the offender is the first cousin of the victim. Ang ginabuhat aning offender is that he would naga gina sa tawag ginahipo niya ang private parts sa iyang cousin as well as the boobs every now and then. So it happened since 2015 pa, and karon pa nagagats ang young girl to report it to the police officer. So in the information we allege there the relationship of them being first cousins. So that is a relative within the fourth civil degree kay para mo-aggravate ang iyahang penalty na acts of lasciviousness. So ang acts of lasciviousness manggod is ang iyahang penalty is 6 months and 1 day to 6 years. So since aggravated by the crime katungod ang iyahang victim is his first cousin, ang hitabo kay ang pataw sa iyahan na penalty is 4 years and 1 day to 6 years. Any questions so far? Naipangutana?
No, sir.
Wala. All right. Now, moving on to intoxication. So, mitigating circumstance, if it is alleged that you were drunk or heavily intoxicated, it will be mitigating on your part if you are not habitual. And if you were able to drink liquor and it is not subsequent to the plan to commit a felony, so it will be mitigating only on your part. So let's say karon lang ka inom and then you were able to drive your car, and since you were let's say drunk, you hit a passerby, and then let's say he suffered physical injuries, then you will only be able to lower your penalty by the presence of the mitigating circumstance of intoxication. Please remember that when you are intoxicated, your freedom and intelligence is somewhat reduced. So that's why the court also recognizes that it could be used as a mitigating circumstance. Now, na po yung uban na, di ba, na they will drink liquor in order to give them a moral boost in order to do something. Now, kung kanang mong buhaton, then it will be aggravating circumstance. Like for example, niinom ka og let's say Johnny Walker isa ka buok na botelya kay para na kay guts na musulod sa balay sa another person para patyoning tawhanan ni. Now that is aggravating. And also if intoxication is habitual, such habit must be actual and confirmed. So this will be the burden of the prosecution to prove that he is really a habitual drinker. So kailangan we would need witnesses and we would need a device in order to see whether or not his alcohol levels would really are high in order for the aggravating circumstance of intoxication to be present. And lastly, we have here degree of instruction and education. So it will be mitigating circumstance if the low degree of instruction and education, or there is low degree of instruction and education or lack of it, because when you are uneducated, you do not fully realize the consequences of your criminal act. Not just mere illiteracy, but lack of intelligence. So this is much more applicable on penal laws regarding paying your taxes. Let's say you are only up to grade school or high school and that you weren't able to pay your taxes. So the court will reduce your penalty because you do not know what taxes are and how to compute your taxes and where to go to whenever you want to pay your taxes. Now, what would be if it is aggravating circumstance? your high degree of instruction and education. So the offender avails himself of his learning in committing the offense. So for example, you are a certified public accountant and you use that knowledge of yours in order to falsify certain documents, then that act of yours will be aggravating on your part because you used your degree of instruction, you used your knowledge of how to balance the accounts in order for you to falsify a certain document. So that is degree of instruction and education, whether it be mitigating or aggravating circumstance. Naipangutana as to alternative circumstances. Hello? Should we continue? Next question?
Wala, sir.
Wala na, sir.
All right. So let's move on to Title 2, Persons criminally liable for felonies. So Article 16 provides who are criminally liable. The following are criminally liable for grave and less grave felonies: principals, accomplices, accessories. And the following are criminally liable for light felonies: principals and accomplices. That is by virtue of Article 16 of the Revised Penal Code. Now, under this concept, in the commission of the crime, there are two subjects, the passive subject and the active subject. Now, we all know that the offender is the active subject because he is the natural and individual offender. Passive subject is the offended party, who may be an individual, natural person, or a juridical entity. Please remember that only natural persons can be criminals, as only they can act with malice or negligence and can subsequently deprive of liberty. So you cannot accuse a corporation, a partnership, or a cooperative of guilty of the crime of estafa because they do not have these things, or these corporations do not have intent. They cannot be, you cannot gauge from them whether or not they have the intent to defraud another individual. So that's why only natural persons can be criminals. Article 16 immediately gives us the principle. For grave and less grave felonies, all of them are liable. So, see, principal, accomplice, or accessory. But for light felonies, only the principals and accomplices are liable. Anuman, why are accessories exempt from criminal liability in light felonies? Because Article 16, in effect, is an exempting circumstance based on public policy. The reason behind this is that in Article 7, where the general rule is light felonies are only punishable when they are consummated. So, sir, because the role of an accessory is very minor. So there is really no need for them to be liable. So that is the reason why an accessory is not liable in grave or less grave felonies. Now moving on, who are principals? Amongst sir, principal? No, of course not. The following are considered principals: those who take a direct part in the execution of the act. Second, those who directly force or induce others to commit it. And lastly, those who cooperate in the commission of the offense by another act without which it would not have been accomplished. So let's begin with the differentiation of each of the three. When you say principal by direct participation, they are those who take a direct part in the execution of the act. So for example, you robbed the building of the OJ, ikaw lang isa. Are you a principal by direct participation, inducement, or indispensable cooperation? Of course, you are a principal by direct participation because you directly participated mismo in the robbery of the Department of Justice. Now, when you say principal by inducement or induction, those who directly force or induce others to commit it. So usually, Ako, I will induce you. Okay, I will give you a price. I will give you 1 million pesos just for you to kill that man for me. So that is because I commanded, I gave this person a prize. So you are considered as a principal by inducement, and the person who acted and who actually killed the man is a principal by direct participation. Now, principal by indispensable cooperation. Those who cooperate in the commission of the crime by another act without which it would have not been accomplished. So, sir, also difference niya sa direct participation. Di ba? Almost the same ilahang role. So how do you differentiate a principal by direct participation from a principal by indispensable cooperation? Anyone who has an idea? Wala? Sige, I will give you an example, ha? So, let's say, sa crime of rape, ikaw, you want, let's say, simba ko pala yun, ha? Mr. Sumambot wants to rape Miss Gandela. So, but he does not have the courage to rape Miss Gandela. So he sought the help of Mr. Bercero and Mr. De Los Santos. So, ang gibuhat ni Mr. Bercero De Los Santos kay gigunitan nila ang kamot ug legs ni Miss Gandela, and si Mr. Sumambot ang ni-rape kang Miss Gandela. So, here, they cooperated in the commission of the crime by another act. And that act is by withholding or restraining the woman so that she could not fight against her perpetrators. So, naka-accomplish ang rape here, di ba? Because Mr. Sumambot was able to rape Miss Gandela. So, mo ni ang principal by indispensable cooperation. Na klaro? Kay sila manggod, although they do not have carnal knowledge of Miss Gandela, they were there by indispensable cooperation because dili maka-rape si Mr. Sumambot without their help. Clarex?
So who is the principal, sir? Yang tapos
Okay, so in that scenario, who is the principal by direct participation? Who directly took part in the crime of rape? Who
Si
has
Mike,
carnal
sir.
knowledge? Ha?
Sumambot.
Oh,
Si Sumambot, Mike.
Sumambot. Now, who is your principal by indispensable cooperation? Because the crime was committed, as the crime was accomplished, although they just did another act in order for it to be accomplished.
Si Bercero tsaka si Kuan, sir. Yung isa.
De Los Santos, right? Okay, so kada.
Yes, sir.
That is how you differentiate a principal by direct participation from a principal by indispensable cooperation. Sir, can
Principal ka di sa mga, sir. Principal ka di sa bing gagapos.
Yes, principal gyapon. And gina-presume po dato diri ang conspiracy. Diba? Kay all of you agreed to commit a crime and decide to commit it. Diba? So always na ay conspiracy sa ilaha. Okay, so let's begin with principal by direct participation. So what are the requisites? That these people participate in the criminal resolution and that the offenders, co-principals, carried out the resolution by performing acts which tend to accomplish the objective. So these are your requisites. Now, for the first requisite, this is tantamount to saying that they are in conspiracy with each other because they participate in the criminal resolution, diba? So there must be a conspiracy between them. Remember that a conspiracy, as defined in Article 8, is an agreement between two or more persons and they agree to commit it. As to your second requisite, in effect, they should be present at the time of the commission of the crime. So you plan, at the same time, you implement the plan. Now that is your second element. Example, 5 people, A, B, C, D, and E, decided in their condominium to rob a bank. They simultaneously entered a bank and were armed. Per instruction, A will disarm the security guard, B will hurt all the people in the bank, C and D will start scooping the money from the teller's booth and vault, then all of them will simultaneously withdraw from the bank. Then the vehicle outside driven by E will be used as getaway car. They were able to escape. Question, is there conspiracy?
Yes, sir.
Yes, very good. Second question, what is their participation in the crime? Are they principal by direct participation, principal by inducement, or principal by indispensable cooperation?
Sir, atong last, sir.
Indispensable cooperation, sir.
Are you sure?
Direct participation.
Di ba in robbery, there is intent to gain? Now, kinsa ang na-intent to gain sa ilaha?
Sila tanan, sir.
Yes,
Sila
sila tanan. Yes, so kung sila tanan na-intent to gain, they are
Direct.
principals by
Direct ban, sir.
participation. Yes. So, for example, the robbery. So let's say they meted out with a penalty of prison mayor. So that's 6 years and 1 day to 12 years. What will be the penalty of A? What will be the penalty of B? What will be the penalty of C? And what will be the penalty of D and E?
Masa itong question, sir?
Given judgment was rendered on them, let's say prison mayor, tapos ang prison mayor is 6 years and 1 day to 12 years. Now, what would be the penalty of A, B, C, D, and E?
Same silang tanan, sir. Since
Yes.
conspiracy.
The same sila.
Same sila
Yes,
na
the same sila
kuan.
because the act
penalty.
of one is the act of all.
Of all. One for all silang kibali.
Yes, the act of one is the act of all. Problem. Bruno and his brothers, Armando, Fernando, and Alejandro, conspired to kill Ken. They met several times and planned. In the final meeting, they decided to implement the plan. Then the following day, one of the brothers, Alejandro, had cold feet. He did not show up. So, only 3 brothers were there at the meeting place, and they agreed to proceed with the crime. So they went with the plan, minus the other brother, and they were able to kill Ken. Question is there conspiracy?
Yes.
Okay.
Nasa.
What is the participation of Bruno, Armando, and Fernando in the crime?
Bruno, Armando, and kuan, sir, is kuan. Direct gihapon, sir. Kay giplano man nila sila tulo.
Okay, why? What is the intent of Bruno, Armando, and Fernando?
Unsa, sir?
What is the intent of Bruno, Armando, and Fernando?
To kill Kin.
Okay, very good. So,
Plan to kill Kin.
how about Alejandro? What is the participation of Alejandro?
Si Alejandro katong isa. Yang ngong part na diyan direct participation. Nakalimutan kong isa unang tawag sa to. Pero aw niyan sang part na apil gihapon niya ando wa naan ka wala niya natapos ang they didn't accomplish the plan sa tong participation.
Are you sure? Remember the requisites of principal by direct participation.
Katong dili si Alejandro, sir, dili na siya direct participation. Katong pang ika-3 nga participation, kato na siya. Dito na siya na part.
Yeah, so that's why I'm asking. How about Alejandro? Is he criminally liable?
Yes, he is criminally liable.
Why? Are you sure?
Time pa, sir.
Okay, let's go back to the requisites. First, these people participated in the criminal resolution, meaning they agreed that they will commit a crime. Is it in the problem? Hello? Naba sa problem na kaning mga tawhanan na ni nag-agree sila to commit the crime.
Yes, sir.
Yes, di ba? Second, that the offender's co-principals carried out the resolution by performing acts which tend to accomplish the objective. Did all of them perform the act and accomplish the objective?
No, sir.
No,
Yes, sir.
di ba? Kinsang wala? Kinsang
Si
wala?
Alejandro, sir. Si
Yes,
Alejandro, sir.
So Alejandro cannot be a principal by direct participation. As a matter of fact, he is
Wala
not
siya.
criminally liable, di ba?
Yes. Opo. Kaya pala. Sorry,
Yeah.
sir.
So always para dili mo mangawala, always go back to the requisites. Okay, para dili mo mag-overthink. Okay, I think during the exam kamuta na nag-overthink mo mao na inyong scores kay nag-ipang unsa mag-ipang atsa mo sa exam last time. And that is actually the case of People versus Timbol. The Supreme Court said that one who did not show up is not liable. The second element, the offender's co-principals carried out the resolution by performing acts which tend to accomplish the objective is actually missing. He did not appear at the scene of the crime. So let's continue next time. We will be discussing the rest of the who are criminally liable and perhaps start with penalties. Gamay antos na lang and we will be done.